gentlemen, as you know, you are considering the case of the state of Georgia versus Kianna Davis. The grand jury has indicted this defendant for malice murder, felony murder, cruelty to children, felony murder, aggravated assault, murder in the second degree, and cruelty to children in the second degree. And the indictment reads as follows. It charges her in count 1 with malice murder for that the said accused in the state of Georgia and the county of Houston between the 15th day of November 2020 and the 17th day of November 2020, the exact date of the offense being unknown to the grand jury, did unlawfully with malice aforethought cause the death of Carter Ambrose, a human being, by beating said victim with an object, the exact nature of which is unknown to the grand jury. Count 2 charges her with felony murder for that the said accused in the state of Georgia and the county of Houston between the 15th day of November 2020 and the 17th day of November 2020, the exact date of being unknown to the grand jury, while in the commission of the offense of cruelty to children in the first degree, a felony, did cause the death of Carter Ambrose, a human being, by beating said victim with an object, the exact nature of which is unknown to the grand jury, which caused cruel physical pain, to wit a lacerated liver, and said victim is a child under the age of 18 years. Count 3 charges cruelty to children in the first degree. The said accused in the state of Georgia and the county of Houston between the 15th and 17th day of November 2020, the exact date being unknown to the grand jury, did maliciously cause Carter Ambrose, a child under the age of 18 years, cruel physical pain by striking said child with an object, the exact nature of which is unknown to the grand jury, which caused a laceration to said child's liver. Count 4 is felony murder for that the said accused in the state of Georgia and the county of Houston between the 15th and 17th day of November 2020, the exact date of the offense being unknown to the grand jury, while in the commission of the offense of aggravated assault, a felony, did cause the death of Carter Ambrose, a human being, by striking said victim with an object, the exact nature of which is unknown to the grand jury, which when used offensively against the person is likely to result in serious bodily injury. Count 5 is aggravated assault for that said accused in the state of Georgia and the county of Houston between the 15th and 17th day of November 2020, the exact date being of the offense being unknown to the grand jury, to make an assault upon the person of Carter Ambrose with an object, the exact nature of which is unknown to the grand jury, an object which when used offensively against a person is likely to or does result in serious bodily injury, by striking said victim with said object causing a laceration to the liver. Count 6 is murder in the second degree. The accused in the state of Georgia and the county of Houston on or between the 15th and 17th day of November 2020, the exact date being unknown to the grand jury, did commit the offense of murder in the second degree. The accused caused the death of Carter Ambrose, human being, irrespective of malice, while in the commission of cruelty to children in the second degree, by failing to seek immediate medical attention for said child for his lacerated liver. Count 7 is cruelty to children in the second degree, for that the said accused in the state of Georgia and the county of Houston between the 15th day of November 2020 and the 17th day of November 2020, the exact date being unknown, with criminal negligence, caused the death of Carter Ambrose, a child under the age of 18 years, cruel physical pain by failing to seek immediate medical attention for said child for his lacerated liver. All of these being contrary to the good order, peace, and dignity thereof. This indictment was returned by the Houston County Grand Jury on the 17th of October 2023. Now the defendant has entered a plea of not guilty to this indictment, and the indictment and the plea form the issue that you're to decide. Neither the indictment nor the plea of not guilty should be considered as evidence. The defendant is presumed innocent until proven guilty. The defendant enters upon the trial of the case with a presumption of innocence in her favor. This presumption remains with the defendant until it is overcome by the state with evidence that is sufficient to convince you beyond a reasonable doubt that the defendant is guilty of the offense or offenses charged. No person shall be convicted of any crime unless and until each element of the crime is proven beyond a reasonable doubt. The burden of proof rests upon the state to prove every material allegation of the indictment and every essential element of the crime charged beyond a reasonable doubt. There is no burden of proof upon the defendant whatsoever, and the burden never shifts to the defendant to prove innocence or to introduce evidence. However, the state is not required to prove the guilt of the accused beyond all doubt or to a mathematical certainty. A reasonable doubt means just what it says. It's a doubt of a fair-minded, impartial juror who's honestly seeking the truth. A reasonable doubt is a doubt based upon common sense and reason. It does not mean a vague or arbitrary doubt, but it's a doubt for which a reason can be given, arising from a consideration of the evidence, the lack of evidence, or conflict in the evidence. After giving consideration to all the facts and circumstances of the case, if your minds are wavering, unsettled, or unsatisfied, then that's a doubt of the law, and you must acquit this defendant. But if such doubt does not exist in your mind as to the guilt of the accused, then you would be authorized to convict the defendant. If the state fails to prove the defendant's guilt beyond a reasonable doubt, it would be your duty to acquit. Facts and circumstances that merely place upon the defendant a grave suspicion of the crime charged, or that merely raise a speculation or conjecture of the defendant's guilt, are not sufficient to authorize a conviction of this defendant. Now, members of the jury, it is my duty and responsibility to determine the law that applies to this case and to instruct you on that law. Obviously, that's what I'm doing now. You are bound by these instructions. It is your responsibility to determine the facts of the case from all the evidence that's been presented. Then you must apply the law that I'm giving you in this charge to the facts as you find them to be. Your oath requires that you decide this case based on the evidence. Evidence is simply the means by which any fact that is put in issue is either established or disproved. Evidence includes all of the testimony of the witnesses and any exhibits that were admitted during the trial. Evidence does not include the indictment, the plea of not guilty, the opening or closing remarks of the attorneys, or the questions asked by the attorneys, only the answers given by the witnesses. Evidence may be either direct or circumstantial or both. In considering the evidence, you may use reasoning and common sense to make deductions or reach conclusions. You should not be particularly concerned about whether the evidence is direct or circumstantial, but I am going to define this for you. Direct evidence is the testimony of a person who asserts that he or she has actual knowledge of a fact, such as an eyewitness. Circumstantial evidence is proof of a set of facts and circumstances that tend to prove or disprove another fact by inference, that is, by consistency with such fact or elimination of other facts. There is no legal difference in the weight you may give to either direct or circumstantial evidence. You would be authorized to convict only if the evidence, whether direct, circumstantial, or both, excludes all reasonable theories of innocence and proves the guilt of the accused beyond a reasonable doubt. Now, as jurors, you must determine the credibility of witnesses. In deciding this, you may consider all the facts and circumstances of the case, including the witness's manner of testifying, their means and opportunity for knowing the facts about which they testify, the nature of the facts about which they testify, the probability or improbability of their testimony, their interest or lack of interest in the outcome of the case, and their personal credibility insofar as you were able to observe it. Now, testimony has been given in this case by certain witnesses who are termed experts. Expert witnesses are those who, because of their training and experience, possess knowledge in a particular field that's not common knowledge or known to the average citizen. The law permits witnesses to give their opinions based upon that training and experience. You're not required to accept the testimony of any witness, expert or otherwise. Testimony of an expert, like that of all witnesses, is to be given only such weight and credit as you think it's properly entitled to receive. To impeach a witness is to show that witness is unworthy of belief. A witness may be impeached by disproving the facts to which that witness testified. Your assessment of a trial witness's credibility may be affected by comparing or contrasting that testimony to statements or testimony of that same witness before the trial started. It is for you to decide whether there is a reasonable explanation for an inconsistency in a witness's pretrial statements and testimony when compared to the same witness's trial testimony. As with all issues of witness credibility, the jury must apply your common sense and reason to decide what testimony you will believe or what testimony you do not believe. The testimony of a single witness, if believed, is sufficient to establish a fact. Generally, there is no legal requirement of corroboration of a witness, provided you find the evidence to be sufficient. A statement that the defendant has made has been offered for your consideration. Before you may consider this as evidence for any purpose, you must determine whether the defendant's statement was voluntary, and if the statement was given in custody, whether the defendant was properly advised. These statements were not given in custody. So you can disregard that last sentence. To be voluntary, a statement must be freely and willingly given without coercion, duress, threats, use of violence, fear of injury, or any suggestions of promises of leniency or reward. A statement induced by the slightest hope of benefit or the remotest fear of injury is not voluntary. To be voluntary, a statement must be the product of free will and not under any compulsion or necessity imposed by others. Now, this defendant is charged with crimes against the laws of this state. A crime is simply a violation of a statute in which there is a joint operation of an act and an intention. Intent is an essential element of any crime and must be proved by the state beyond a reasonable doubt. Intent may be shown in many ways, provided you, the jury, believe it existed from the proven facts before you. It may be inferred from the proven circumstances or by acts and conduct, or it may be in your discretion inferred when it is the natural and necessary consequence of the act. Whether or not you draw such an inference is a matter solely within your discretion. The defendant will not be presumed to have acted with criminal intent, but you may find such intention or the absence of it upon consideration of the words, conduct, demeanor, motive, or other circumstances connected with the act for which the accused is being prosecuted. Every person is presumed to be of sound mind and discretion, but this presumption may be rebutted. You may infer, if you wish to do so, that the acts of a person of sound mind and discretion are the product of that person's will. A person of sound mind and discretion intends the natural and probable consequences of those acts. Whether or not you make such an inference or inferences is a matter solely within the discretion of the jury. Now, you should know every party to a crime may be charged with and convicted of the commission of a crime. A person is directly a party to a crime only if that person directly commits the crime, intentionally helps in the commission of the crime, intentionally advises, encourages, hires, counsels, or procures another to commit the crime. Any party to a crime who did not directly commit the crime may be prosecuted for commission of that crime upon proof that the crime was committed and that the person was a party to it, even though the person alleged to have directly committed the crime has not been prosecuted or convicted, has been convicted of a different crime or degree of crime, is not amenable to justice, or has been acquitted. Knowledge on the part of this defendant that the crimes alleged here were being committed and that the defendant knowingly and intentionally participated in or helped in the commission of such crime must be proved by the state beyond a reasonable doubt. If you find from the evidence in this case that this defendant had no knowledge that a crime was being committed, or that the defendant did not knowingly and intentionally commit, participate, or help, or was not a conspirator in the alleged offense, then it would be your duty to acquit the defendant. On the other hand, should you find beyond a reasonable doubt that the defendant had knowledge that the crime charged here was being committed, and that the defendant knowingly, intentionally participated or helped in the commission of it, you would be authorized to convict. A jury is not authorized to find a person who is merely present at the scene of the commission of a crime at the time of its perpetration guilty of, consent in, and concurrence in the commission of the crime unless the evidence shows beyond a reasonable doubt that such person committed the alleged crime, helped in the actual perpetration of the crime, or participated in the criminal endeavor. A jury is not authorized to find a person who is merely associated with other persons involved in the commission of a crime, guilty of consent in or concurrence in the commission of the crime, unless the evidence shows, beyond a reasonable doubt, that such person helped in the actual perpetration of the crime or participated in the criminal endeavor. Now, members of the jury, the law of our state sets a time limit upon the state in starting the prosecution of most criminal offenses. The accused is on trial for the offenses of murder, aggravated assault, cruelty to children in the first and second degree. Under Georgia law, there is no statute of limitations for any of the types of murder charged. However, prosecution for the offenses of aggravated assault, cruelty to children in the first degree, and cruelty to children in the second degree must begin within 4 years after the offense has been committed. If you find from the evidence that the indictment in this case was not filed within 4 years after the offense was committed, it would be your duty to acquit this defendant. The law provides that criminal actions shall be tried in the county in which the crime was committed. We call that venue. That's the crime was committed in house and county. And that's a jurisdictional fact that must be proved by the state beyond a reasonable doubt as to each crime charged in the indictment, just as any element of the offense. Venue may be proved by direct or circumstantial evidence or both. Criminal homicide shall be considered as having been committed in the county in which the cause of death was inflicted. All right, let's talk about the specific charges. For malice murder, the state must prove that the defendant caused the death of another person unlawfully and with malice aforethought. The killing must have been done with malice to be malice murder. Malice, as the term is used here, is not necessarily ill will or hatred. Rather, it is the unlawful intent to kill without justification, excuse, or mitigation. You may find malice when the circumstances show that the defendant acted with the deliberate intention to unlawfully take the life of another person. You may also find malice when there does not appear to be significant provocation and all circumstances of the killing show an abandoned and malignant heart. The state does not have to prove premeditation to prove murder. If the killing is done with malice, it is murder, regardless of how briefly the malicious intent existed. No specific length of time is required for malice to arise in the defendant's mind. Malice may be formed in a moment, and instantly a fatal wound may be inflicted. If malice was in the defendant's mind at the time of the act or the killing, and moved the defendant to do it, that is enough for the killing to be murder. The state does not have to prove motive to prove murder. Any evidence of motive that's been admitted for your use in determining the defendant's state of mind at the time of the killing. All right, for felony murder, the state must prove that the defendant caused the death of another person by committing a felony. The state does not have to show that the defendant acted with malice to prove felony murder. Count 2 charges felony murder with cruelty to children in the first degree as the underlying felony. So I want to define cruelty to children for you, and that would be the same definition for Count 2's felony murder portion and Count 3, which is the actual cruelty to children in the first degree. Okay, so I'm going to define that for you now. For cruelty to children in the first degree, the state must prove that the defendant maliciously caused cruel physical pain to a child under the age of 18. In deciding whether the defendant acted maliciously, understand that malice is not ill will or hatred. Malice in this context, means an intent to cause the pain without justification or excuse. Malice also means willfully doing an act while aware of a strong likelihood that the pain may result. count 4 charges felony murder with aggravated assault as the underlying felony, and count 5 is the aggravated assault. I'm going to define aggravated assault for both of those. And felony murder is the same, right? And the cause of death and the commission of a felony. But in counts 4 and 5, that underlying felony is aggravated assault, okay? Aggravated assault, the state must prove that the defendant assaulted another person with an offensive weapon. An offensive weapon is any object that is likely to or actually does cause death or serious bodily injury if used against someone. In deciding whether the unknown object charged here is an offensive weapon, you may consider all of the following factors: the nature and extent of any injury inflicted, the character and capabilities of the weapon, the manner in which it was used, any display of it to the jury, and any other circumstances of the case. Count 6 is murder in second degree. For murder in the second degree, the state must prove that the defendant caused the death of another person by committing cruelty to children in the second degree. The state does not have to show that the defendant acted with malice in order to prove murder in the second degree. Cruelty to children in the second degree is the count number 7. I'm going to define that for you now, and that should also be the definition you use in considering count number 6, the murder in the second degree. Cruelty to children. For cruelty to children in the second degree, the state must prove that the defendant caused cruel physical pain to a child under 18 through criminal negligence. Criminal negligence is a failure to act which shows a willful, wanton, or reckless disregard for the safety of others who might reasonably be expected to be injured by the failure to act. Now, an accident is an event that occurs without the defendant planning, expecting, or anticipating it. You may not find the defendant guilty of a crime if the alleged criminal act was committed by accident and there was no criminal scheme, criminal intent, or criminal negligence by this defendant. I want to define criminal negligence for you in this context. Criminal negligence is a failure to act which shows a willful, wanton, or reckless disregard for the safety of others who might reasonably be expected to be injured by that failure to act. If the defendant raises a defensive accident, the state has the burden to disprove the accident beyond a reasonable doubt. All right. You must reach a verdict as to, let me try again. If after considering the testimony and the evidence produced to you, together with the charge of the court, you should find and believe beyond a reasonable doubt that the defendant in Houston County, Georgia, did on or between November 15th through 17th of 2020 commit one, some, or all of the offenses as alleged in this indictment, then you would be authorized to find the defendant guilty. In that event, the form of your verdict would be, we the jury as to whichever counts, find the defendant guilty. If you do not believe that the defendant is guilty of one, some, or any of these offenses as alleged, or if you have any reasonable doubt as to the defendant's guilt, then it would be your duty to acquit the defendant, in which event the form of your verdict would be, we the jury as to whichever counts, find the defendant not guilty. A conviction on one count of the indictment does not require there be a conviction on other counts. It is the duty of the jury to consider each charge of the indictment separately. Now, by no ruling or comment that the court has made during the progress of this trial, have I intended to express any opinion on the facts of this case, the credibility of witnesses, the evidence, or the guilt or innocence of the defendant. Your verdict should be a true verdict based upon your opinion of the evidence according to the law given you in this charge. It's your duty to consider the facts objectively, without favor, affection, or sympathy to either side. You are only concerned with the guilt or innocence of the accused. You are not to concern yourself with punishment. That is an issue for the court in Georgia. Now, one of your first duties in the jury room will be to select one of your members to act as foreperson who will preside over your deliberations and sign the verdict to which all 12 of you freely and voluntarily agree. You should start your deliberations with an open mind. Consult with one another. Consider each other's views. Each of you must decide this case for yourself, but you should only do so after discussion and consideration of the case with your fellow jurors. Do not hesitate to change an opinion if you're convinced that it is wrong. However, you should never surrender an honest opinion in order to be congenial or to reach a verdict solely because of the opinions of the other jurors. Whatever your verdict is, it must be unanimous, that is agreed to by all 12. Must be in writing, signed, and by your foreperson, dated, and returned to be published in open court. All that means, y'all, is I'm going to give you a verdict form. You're going to circle your verdict, guilty or not guilty, as to each count. You'll give it to the bailiff. I'll read it out loud once you're ready to do that. I'm going to let you retire from the jury room in just a second. I'm going to ask you not to begin your deliberations until you receive the indictment, the verdict form, and the evidence that's been admitted. If you have questions during the deliberations, they should be written down on a piece of paper, signed by your foreperson. You flip the light, the bailiff will bring them to me, and I'll respond to those. We've been at it a while, so I know y'all are going to need a break before you start your deliberations. Here is, let me give you a caveat about that. You can talk about the case only when all 12 of you are in the room. So if somebody's outside smoking or somebody's in the bathroom, you have to stop talking about the case until all 12 of you are back. So I'm going to let you retire to the jury room, take a break, just a minute, but don't start deliberating until all 12 of you are back in there. I have 2 alternates in this case. That's going to be Mr. Reuter, am I saying it right? Reuter, and okay. So you guys will be in a separate room. You will not participate in deliberations unless that becomes necessary because one of the others cannot finish. Okay? With that, y'all take a break, retire to the jury room, please. All right. Objections to the charge from the state?
No, Your Honor.
From the defense?
No, ma'am, none.
All right. I am printing the verdict form. Y'all need to look at. No, hold on a second. Let me not do that. Here is the indictment. That needs to go down there. Y'all make sure you got all the pictures. Nobody wandered off with anything, please. I stuck it in there already.
Okay. Yeah.
Right?
I couldn't remember if you said take it out.
No. I think it should have those in there. So the videos will stay here. There should be the medical records and the photographs is all I've got, right? And the email.
That's all you're on.
All right, y'all want to look at this verdict form and make sure there's nothing swirly in there. I've got them numbered right and the right number, case number and stuff on there. It's yeah.
What's this like? Okay.
be able to come with work for me.
It's good.
All right, so put it on top of your stuff and give that to Mr. Davis, the indictment too. All right, Mr. Davis, you can take that. We'll stand in recess till we hear from council. Y'all make sure the bailiffs know where to find you. Because I suspect
We'll be back shortly.
that would be my guess, with questions or request to review a video, but we'll see. Y'all be seated. All right, is Zach, if we didn't turn the light off last time, or they got another question?
I believe it's the same light.
Okay. You ready? Okay, so we have a question from the jury. I am marking the written question. Number 1, it says, can we please be provided the definitions that were provided by the judge during the final instructions? I am assuming that they want the definitions for the charges specifically, but I need to ask that. So, counsel, what I'm going to do is I'm going to send them a question back in writing that says, do you mean the definitions for the specific charges? And if they say yes, then I'll bring them out and recharge them on that. If they say no, then we'll figure out what they do mean. Okay?
This man, no objection.
Mr. Dwayne?
There's no objection to it.
Okay. Take that and just tell them to flip the light when they have an answer for me. And we'll just sit right here because I'm 80% sure that's what they mean, but you know what they say about assuming, so I want to make sure I'm clear what they mean before we go. If that is what they want, then I will I'll read just the charges and then remind them that they need to take that as part of the charges, consider all of the rest of the charge and reaching a verdict. There you go. Yes, the ones that explain malice, child cruelty, etc. Okay, so I'm going to recharge on malice murder, felony murder, aggravated assault, and the 2 cruelty charges. You bring them in, please. All right, I don't need the alternate.
Uh,
All right, ladies and gentlemen, y'all have asked to be recharged on the specific charges, the definitions of each charge, so I'm going to do that now. I just will remind you that you're hearing the portion that is specific to these counts, but also you should consider those in light of the entire charge when you get back in there, okay? All right, malice murder. For malice murder, the state must prove that the defendant caused the death of another person unlawfully and with malice aforethought. The killing must have been done with malice to be murder, or to be malice murder. Malice, as the term is used here, is not necessarily ill will or hatred. Rather, it is the unlawful intent to kill without justification, excuse, or mitigation. You may find malice when the circumstances show that the defendant acted with a deliberate intention to unlawfully take the life of another person. You may also find malice when there does not appear to be significant provocation and all the circumstances of the killing show an abandoned and malignant heart. The state does not have to prove premeditation to prove murder. If a killing is done with malice, it is murder regardless of how briefly the malicious intent existed. No specific length of time is required for malice to arise in the defendant's mind. Malice may be formed in a moment, and instantly a fatal wound may be inflicted. If malice was in the defendant's mind at the time of the act or the killing and moved the defendant to do it, that is enough for the killing to be malice murder. The state does not have to prove excuse me. The state does not have to prove motive to prove murder. Any evidence of motive that has been admitted for your use in determining the defendant. Let me try again, y'all. Any evidence of motive has been admitted for your use in determining the defendant's state of mind at the time of the killing. For felony murder, the state must prove that the defendant caused the death of another person by committing a felony. The state does not have to show that the defendant acted with malice to prove felony murder. Count 2 charges felony murder with cruelty to children in the first degree as the underlying felony. Cruelty to children in the first degree is a felony for which I'll define for you now. Cruelty to children in the first degree. State must prove that the defendant maliciously caused cruel physical pain to a child under the age of 18. In deciding whether the defendant acted maliciously, understand that malice is not ill will or hatred. Malice in this context means an intent to cause the pain without justification or excuse. Malice also means willfully doing an act while aware of a strong likelihood that the pain may result. Count 4 charges felony murder with aggravated assault as the underlying felony. Aggravated assault is a felony which I'll define for you now. For aggravated assault, the state must prove that the defendant assaulted another person with an offensive weapon. An offensive weapon is any object that is likely to cause or actually does cause death or serious bodily injury if used against someone. In deciding whether the unknown object is an offensive weapon, you may consider all of the following factors: nature and extent of any injury inflicted, the character or capabilities of the weapon, the manner in which it was used, any display of it to the jury, or any other circumstances of the case. Murder in the second degree. For murder in the second degree, the state must prove that the defendant caused the death of another person by committing cruelty to children in the second degree. The state does not have to show the defendant acted with malice to prove murder in the second degree. Let me define cruelty to children in the second degree for you now. For cruelty in the second degree, the state must prove that the defendant caused cruel physical pain to a child under the age of 18 through criminal negligence. Criminal negligence is a failure to act which shows a willful, wanton, or reckless disregard for the safety of others who might reasonably be expected to be injured by this failure to act. Alright, take that with all of the other, I wanted to make sure I defined criminal negligence. I did. Okay. So take that in accordance with all of the law that I've given you and facts that you find them to be, and I'll let you resume your deliberations. Thank you, ladies and gentlemen. Alright, my intention is if we do not hear from them again by about 6, I will inquire if they want to continue or go home for the night. If they go home for the night, we're going to have to resume Friday morning, which is not ideal, but I cannot be here tomorrow. So we knew we were going to have to work around that. So we'll just wait until we hear from them.
Is there a judge, Your Honor, that could potentially take the verdict tomorrow?
No, I don't think that's a good idea, because if we get questions or we get issues, that becomes more complicated. And I'm not sure Judge Smith or Judge Adams are available, but we'll see. Let's see where we are then. All right, we'll stand in recess till we hear further from them. All right. Okay. We have we have two more questions from the jury. First, what about if we believe the injury happened on Saturday, the 14th, but the indictment lists 15th to 17th? And then the jurors would like to ask if we can come back tomorrow. So, first, on or about means if they think it happened on the 14th, I think that's sufficient. There is some language about that in the law that I want to be precise in how we charge them on that. And the other thing that's messy in trying to answer that question is the death occurred on the 17th. And so, the elements of the crime, you see what I'm, so if it's felony murder and the aggravated assault, it's a little bit messy. So, y'all take a minute and think about what you think is the appropriate response to that. I don't think there's any question that the law says, and the indictment reads on or about, or on or between, whatever. So I don't think that is dispositive of the issue. And then, hang on, I'm going to let you both say what you want to say. And so when you are telling me what you think about it, number one, also, does it matter which charge we're talking about when we're talking about the date? Because does the homicide happen the day the injury is inflicted, the day of death, either or, depending on how it's indicted? And so those are the sorts of things we need to consider when we're talking about how we respond to that question.
May I?
Yes.
So I've used a charge in the past where the date is not a material element.
Right.
And they can be charged with that, and I can run back to my office and try to find a copy of that.
Well, that's what I was talking about when I said the on or about. I probably can pull it right here for you, but I think that's the start of the conversation.
May I respond?
You may. Go ahead, Mr.
Kianna, please. Normally an indictment will say that, but the indictments on all these counts say between the 15th day of November 2020 and the 17th day of November of 2020. The exact date of the offense being unknown to the grand jury. I say that because all of the counts say that. It doesn't say on or about.
Okay. But it does say on or between and the exact date being unknown. And I think that if you look in, so there are some cases, as he's saying, the date recited in the indictment is not a material element of the offense unless the indictment specifically provides to the contrary. So as long as the offense occurred within the statute of limitations. A date is a material allegation of an indictment if it is an essential element of the charged offense or if a defense such as alibi has been asserted. And that is not the case here. And let me look at the specifics of this. I'm looking at some cases, hang on. All right, if you look at Townsend v. State, which is 357 Georgia Appeals 111, this actually is working in reverse. So it's well settled that the date is not a material element, and as long as it is proved within the statute of limitations, in the absence of a specific allegation that is a material element or an alibi defense, then you're not stuck with the date. And in Townsend, this is actually a post-conviction argument about merger and whether these theft crimes merge. And the state is arguing that they do not because they were alleged to have happened on different dates. But they're all the same victim, the same stuff, and they do merge because the state failed to allege the date was a material allegation. So I think, whichever way you come at it, the answer is that the date is not an essential element of the crime charged as long as a crime has occurred within the statute of limitations.
And we will not concede that point.
Okay, then that's fine. And so, let me, I want to look at one other thing before I if y'all look at Reed v. State, which is a Supreme Court case from 294 Georgia 877, that's March 28th of 2014. Where the date is not alleged to have been an essential element, the defendant did not assert an alibi. And this is a homicide case, and so and in that case it was May instead of March, not within 24 hours, and the Supreme Court says even though it's been held that a definite date of an offense should be alleged in an indictment, the state is not restricted to proof of the date stated. It is sufficient if the evidence demonstrates that the offense was committed at any time within the statute of limitations, except where there's an alibi or it's alleged that it's an any variance except in the absence of an alibi or being made an essential element is of no consequence. So I think the correct response is that hold on a second, let me think out loud. I'm going to tell you exactly what I'm going to say and then let you both comment for the record as the law requires. All right, what I would like to respond to this question is, the state is not restricted to proof of the date stated in the indictment. It is sufficient if the evidence proves beyond a reasonable doubt the offense or offenses occurred within the statute of limitations.
Can you repeat it again, please?
The state is not restricted to proof of the date stated in the indictment. It is sufficient if the evidence proves beyond a reasonable doubt that the offense or offenses occurred within the statute of limitations.
I think that's okay.
Mr. Grigg?
Of course, I don't have any legal cases to cite to the court, but I would object to that.
All right. Your objection's done for the record. I'm going to give that, I'm going to write that exact wording down to respond to their question.
And I have no objection to them coming back another day.
Okay, and I'm just going to tell them the choice is tonight or Friday morning at 9.
I would ask them, essentially, see if they'll return the verdict tonight, Judge, based on.
I will let them choose if they want to stay tonight or they want to come back Friday. And I'll just tell them that they've been on our schedule, we're on theirs.
Yes, Your Honor.
But I need to not write and talk. I wrote, the state is not restricted to proof of date stated in the indictment. It is sufficient if the evidence proves beyond a reasonable doubt the offense or offenses occurred within the statute of limitations. And I also wrote, you may continue to deliberate tonight or come back Friday morning. The court will be unavailable tomorrow. Either is fine, just let us know. You may also take a break when needed. Mr. Davis, take that to them, please. No, I said the court is unavailable tomorrow. Let's wait a second and see if they're going to tell us what they want to do before we all disperse. And they've still got the light on, Bob, so. We won't know when they need us if they don't turn it on next week.
It's back on.
Okay, the note says, we have one juror who says she isn't open to discussion, who is combative to the room. What do we do here? She said she will not change her mind in a million years. Please advise. So, the issue for the court is a juror should never surrender an honest opinion. But a juror does have to participate in deliberations. So my suggestion at this point is that we Allen charge them, because that talks about you have to listen to each other. Let me pull that and look at the pattern. Because we have to be very careful with investigating which it is. That a juror has a belief based on the evidence that they're unwilling to surrender, which the system is set up for, or whether a juror is just refusing to deliberate.
And Judge, I would argue to the court, I don't think we've got far enough yet. I think it's probably too early to do an Allen charge.
Okay, go ahead.
I would suggest that we come back Friday morning and give them some more time to deliberate, and then after a period of time that the court deems appropriate, if the stance is still that way, then do the Allen charge.
Well, I think it's not so much the first paragraph of the Allen charge, but the second part that says each juror should listen to the arguments of the other jurors with a disposition to be convinced by them. If the members of the jury differ in their view of the evidence, that difference of opinion should cause them all to scrutinize the evidence more closely, re-examine the grounds of their opinion. Your duty is to decide the issues that have been submitted to you. If you can, conscientiously do so. In conferring, you should lay aside pride of opinion. Bear in mind that the jury room is no place for taking up and maintaining, in the spirit of controversy, either side of a cause. You should bear in mind at all times that as jurors, you should not be advocates for either side. You should keep in mind the truth as it appears from the evidence, examined in light of the instruction of the court. I would encourage you to continue this case. I mean, because just sending them home is not going to change the dynamic. I don't know that the dynamic should change. I don't know what, because combative is one thing, never surrendering an opinion in a million years is a different one from a legal standpoint. And the court has to be very careful in invading the province of the jury. However, I'm talking myself around into what I think is the appropriate thing. It is late. Everybody's tired. I think I'm going to send them home, tell them to come on back Friday morning at 9, that, and I may, then we'll, I'm open to thoughts on whether I should address, if I need to address this at all, or just send them home today.
I'm in agreement to send them home and bring them back Friday morning.
Mr. Grew?
I would think so also.
All right, if that's what y'all think. Bring them in for me, Mr. Douglas.
Do you want alternates then?
Yeah, because we may need them.
If I may make one comment, Judge, when you say them home, the media coverage has been everywhere.
Yeah. I will remind
It's
you.
all over.
Yeah, I know.
She wants y'all to consider about.
Ladies and gentlemen, it's been a long day. We're going to stop here for tonight. Unfortunately, I have somewhere to be tomorrow that is not here, that I cannot get out of. So we're going to reconvene Friday morning at 9 o'clock. Now, you can go on any computer and watch this whole trial again. I need you to understand, you cannot do that. Don't look at MAZ, don't look at Court TV, don't look at Fox, don't look at WGXA, none of them, okay? That is improper, and it will affect the ability of this court to finish this case. Don't talk about the case with anybody over the weekend or overnight. Just try to put it in a box until Friday morning, okay? Don't do any independent research. Don't go looking stuff up. All of that is improper, okay? So you're just going to shelve it for tonight. I will see you back here Friday morning about, let's aim for y'all coming in at 8:45. If all 12 of you are in the room, you can start deliberating. As you're coming in the morning, if there are 5 of you and that's all, you cannot talk about the case until all 12 of you are present. Okay? All right. Leave your notepads in your chairs or in the jury room on your way out. And I will see you back here at 8:45 Friday morning. Okay? Thank you, ladies and gentlemen.
Okay, Don.
For the, who has handed me another, she maintains she's being harassed by the foreperson about her vote. So I'm assuming, so we're gonna send everybody home, let everybody cool off, and then, y'all be prepared to, discuss what is the appropriate remedy on Thursday and what, if any, investigation the court can properly engage in.
Judge, for that reason, I would want to make sure that the alternates are here on Friday.
Yeah, they will be. I've instructed them to come back with the rest. Anything else for the record?
Not from the state.
Nothing from us, Your Honor.
All right. Friday morning, y'all. We'll stand in recess.
Thank you, Your Honor.